The Clayton Antitrust Act of 1914 is a part of United States antitrust law with the goal of adding further substance to the United States antitrust law regime. The Clayton Act seeks to prevent anti-competitive practice in their incipiency. Hello friends, welcome back to the channel. Like, share, subscribe and don't forget to press the bell icon. The Clayton Antitrust Act regime started with the Sherman Antitrust Act of 1890, the first federal law outlining practices that were harmful to consumers, monopolies, cartels, and trust. The Clayton Act specified particular prohibited conduct, the three-level enforcement scheme, the exception and the remedial measure. Like the Sherman Act, much of the substance of the Clayton Act has been developed and animated by the United States Court, particularly the Supreme Court. The Clayton Act made both substantive and procedural modification to federal antitrust law. Substantively, the Act seeks to capture anti-competitive practices in their incipiency by prohibiting particular type of conduct not deemed in the best interest of the competitive market. There are four sections of the bill that proposed substantive changes in the antitrust laws by way of supplementing the Sherman Antitrust Act of 1890. In those sections, the Act thoroughly discusses the following four principles of the economic trade and business: price discrimination between different purchasers. If such a discrimination substantially lessens competition or tend to create a monopoly in any line of commerce. Sale on the condition that the buyer or lessors not deal with the competitors of the sellers or lessors. Exclusive dealings or the buyer also purchase another different product, tying but only when these act substantially lessen competition. Mergers and acquisitions where the effect may substantially lessen competition or where the voting securities and asset threshold is met. Any person from being a director of two or more competing corporations if those corporations would violate the antitrust criteria by merging.